Okay, Jackie. Jackie lives in a complex. Neighbor. Okay, so neighbor's unit has a water leak. Now, further in the question, we get the impression from the insurance company, if I'm not mistaken, or the body corporate, that the water leak is an internal issue. So the reason I'm putting that context in now is because the first thing that comes to mind is, was the leak um, due to a common area issue, or was it due to a issue like whatever, a pipe in like for the bath, but in the unit itself, or a leaking tap, although a leaking tap wouldn't cause this kind of damage, but an actual leak that can be attributed to the neighbor, not to pipes in the wall that belong to the body corporate. So the body corporate or insurance seems to say that it's an internal problem, meaning that it's the responsibility of the owner, not the body corporate. So it's seeped into her walls. This is now the viewer's walls. So from the neighbor to the viewer, seeped into walls, is making it damp. So you can't paint, there's bubbles, that sort of thing. The neighbor refuses to fix the leaks, and it's at a point now where the wall is being affected, and she wants to fix it. She wants to insert a metal frame. She wants to put stuff between the two units that'll stop the leaking. She's asked the body corporate for assistance. No joy there. She lodges a dispute with CSOS, which I think, like you and I both agree, I don't think CSOS would ever adjudicate neighbor issues. And then the situation's been going for 3 months. Okay, so looking for legal practitioner, and she wants to basically either she wants to compel the fixing of the walls, or she seems to want an order where a master builder knocks out a wall and puts in a barrier. And yeah, that's pretty much it. Do you want to start with this one?
Yeah, so yeah, really interesting one. I'm glad you mentioned the origin. So the most important thing, and the thing that really is the difficult part for us as attorneys when we get these things is, where does the leak come from? Okay, and that changes everything when it comes to the legal case. And obviously, when it comes to an external leak that's coming through from a common property or a roof or something like that, then it's a body corporate issue. And when it's internal, it's going to be the owner issue. We'll assume that this is internal in the circumstances, but really, it's luckily this listener's already taken a couple of great steps here. But in respect of, obviously, if the body corporate's not helping, I don't think CSOS is going to be the right one. And I really do think it's a legal practitioner. You need to go see an attorney on this. The listeners obviously suggested breaking down the wall and putting in a metal frame or something. I don't think that's necessary in the circumstances. Yeah. Obviously the leak is originating from something, and generally your pipes are a little bit easier to fix than bashing out a whole wall, between two units in a sectional scheme. So really it's a case of, approaching a legal practitioner to try and get an application to compel. You can already demonstrate that there's some level of damage, and the listener did say that they've already got a contract out twice, to deal with the issue, and they're looking to get a third contractor. So you can already demonstrate at this point that there is a problem. There's a damage which is being suffered by you as the neighbor, okay, and it needs to be remedied because the damage is going to continue. And in those circumstances, it seems to me, just on a face value, that there is sufficient grounds for you to approach a court on a basis to say, look, this needs to be rectified. I need to interdict the owner to remedy the situation so that I don't continue to suffer damages or suffer more damages. If the leak continues or gets worse in the circumstances. I think there's enough to do that in the circumstances. So really, I mean, our listener did say they're looking for a legal practitioner. I think that's the right way to go in the circumstances, to at least get the process running, get your letters of demand out and try see if you can, get the neighbor to actually address the issue now. And then if not, eventually go to court for an application, to compel them to do so.
Yeah. Absolutely. And you know, going to that, the view also needs to remember damages that are being caused can also be accounted for. So obviously, this is a situation where you need an application to compel, because normally as attorneys we look at things from a two-option perspective. So either try fix the issue or fix it yourself and then claim the cost of having fixed it. The difficulty here obviously is if it's a shared wall, you don't go around knocking down walls. I mean, it's just not, I mean, it's going to be highly uncomfortable for you as well. So it's not something that's suggested. You're going to basically live with a roommate for, you know, for a couple of months while this wall is being put up, and it causes bigger issues. So this is unfortunately one of the situations where there isn't much damages that one can say can be claimed afterwards, because to fix the problem, you would actually need the application to compel. So damages, for example, would be any costs that you've had to undertake in the process, any damages that you've experienced, like physical damages. But short of that, the application to compel would do the trick. It is just also a little bit difficult, and I'd suggest, so from a legal practitioner perspective, whether you're in Durban, wherever you are, because I see you said you're in Morningside, Durban, come to either SSLR or BSA law. But like we are national. We've got people all over the place. We can very easily run a matter like this. So feel free to contact us. This is Jackie. But point being that whoever you do contact, just bear one thing in mind: an application to compel is only as good as the paper it's written on. If it's not actually drafted in a very specific way. So imagine you get an order that goes, fix the wall, right? Now you go there, you put this order in the neighbor's face and go, fix the wall. And the neighbor goes, no, right? Now you have to go back to court, but now he's in contempt. What exactly does fix the wall mean? How do you enforce it? What can the sheriff do? Sheriff goes, knocks on that door and says, fix the wall. The sheriff can't compel him to do it. I mean, how do you physically compel someone to do it? It's not like a locksmith where you can unlock the door and there's an active step on your part to do it. So very often with these compelling applications, we try to find different scenarios to play out. But would it be a question of he has to do it? If he doesn't do it, you can do it. What would you doing it look like from a fixing perspective? Let the court go, yeah, that sounds cool. Go for it. Do that. And then, you know, maybe then you can claim the costs back. Maybe you can go to court already with the costs and say, they must do it. Alternatively, I'll do it based on this quote, which I can then claim from him, and those costs are then claimable. So the attorney that's working on this would have to be a little, not creative, but you have a bit more forethought. So don't just go, attorney, you know, cheap charge, go to court, because you're going to land up with an order that you're not going to know what you're going to do with. I'd rather have someone that's going to apply their mind to this and think of the different scenarios to make sure that by the end of this, you can get the sheriff out with a contractor, you can start working on the project, and you've got an order where you can claim the cost back all in one without having to go to court 5 times to try and get it. That's just my 2 cents.
No, 100%. Absolutely. Absolutely.
Yeah.